Welcome back to the channel. This is just a short video to clear up some confusion over whether or not a warrant has to have a wet signature. I have covered this in more detail in other videos, and in fact I've covered warrants in a lot more detail in other videos, which I will link in the description below. The short answer is no, they don't need to have a wet signature. In fact, they don't need to have a signature anymore at all. There's only a few types of complaints that still need to be signed by the Justice of the Peace, but it is also settled law that an electronic signature is suitable. For summons and warrants, they only need to have the date inserted on the back to indicate when they've been issued, but it was the Magistrates Court Rules of 1981, Rule 109, that used to talk about the signatures, but that was removed by the Magistrate Court Rules Amendment statutory instrument, which had the effect that warrants and summons no longer had to have the signature, and in effect they only have to have the date. And as I said, there are 4 different types of complaints which are only necessary for the first instance warrants and a stated case. And as I said, the effect of this is that it requires them to be signed by a Justice of the Peace. But however, as I said, it is settled law that it doesn't need to have a wet ink signature. It can be electronically signed or even just the court stamp. So if anyone is hoping to fight such a warrant solely on the basis that there isn't a wet ink signature on there, I would strongly recommend that you don't do that. You might get yourself into far more trouble than it's worth. If it transpires that for some other reason the warrant wasn't valid, then you can make complaints and take further steps on that, for which of course you'll need to take formal legal advice. So I hope that was a useful clarification. Please give the video a thumbs up, subscribe, and I'll see you next time.